thousands of years, international law has emerged either to meet the needs of sovereign states or in response to catastrophic events. For example, sovereign states recognized that their ambassadors, especially those negotiating peace, must enjoy immunity from arrest, and a principle of customary international law to that effect emerged. Similarly, that persons who sought asylum in places of religious worship should not be arrested, or that treaties should not be broken. Every state had an interest in ensuring that these principles were observed. Later, the humane treatment of prisoners of war and the sparing of the lives of the enemy's unarmed soldiers began to be accepted as principles of customary international law. The need for more precise and clearly defined rules for regulating the relationship of states arose with the emergence of the modern state system in Europe. And the body of international law expanded considerably with the establishment of the Permanent Court of Arbitration in 1899, the Permanent Court of International Justice in 1919, and the establishment of the United Nations in 1946, with the International Court of Justice as its principal judicial organ. However, it was the Second World War and the events that preceded it in Germany, where unprecedented atrocities were perpetrated on millions of its own citizens by the regime then lawfully in power, that led to the establishment of that elaborate regime of international human rights law that prevails today. More people have been lost to the pandemic than were incarcerated in the gas chambers of Nazi Germany. I see hope, therefore, that the frontiers of international law will eventually be advanced to require collective action by states to protect humanity from at least the next pandemic. It is clear that the international health regulations adopted by the World Health Organization sometime in the 1980s and revised in 2005, which are designed to prevent, detect, and respond to public health crises, have proved to be wholly inadequate to deal with the pandemic. It is clear that many developing countries do not have enough economic strength or surveillance or response capacity to confront a pandemic. There is therefore an urgent need for a common and shared responsibility among all countries, big or small, rich or poor, to make it possible for every country to respond effectively to the next pandemic. In this session, you will have the opportunity, or should I say the privilege, of listening to distinguished academics as they present their research on subjects ranging from the rights of indigenous communities, the most vulnerable segment of society at the time of a pandemic, the right to privacy, frequently encroached upon during a pandemic, the right of access to education, which becomes illusory during a pandemic, the right to health, obesity being a common result of a lockdown, now extended by another week, and the rights of the child, the unfortunate helpless victim, as the pandemic claims the lives of his or her parents. I now have the pleasure of introducing the presenters of the first research paper, all of whom are graduates of the General Sir John Kothawala Defence University and are now final year students at the Sri Lanka Law College. Sachini Boraluwa, she obtained her LLB degree from the Kothawala Defence Academy, and she, while being a final year student at Sri Lanka Law College, takes a keen interest in the area of human rights law, international law, environmental law, and international relations. Nimtara Dissanayake also obtained her LLB from the Kotalawala Defence University, and she's also a final year student at the Sri Lanka Law College, and her interests are in the areas of human rights law, international law, and commercial law. And MKG Ranaweera, who obtained her LLB degree from the Kotalawala Defence University, and is also a final year student at the Sri Lanka Law College. And her interest lies in areas of human rights law, intellectual property law, and environmental law. I have great pleasure in calling upon the authors of this paper to speak to us on development and rights of indigenous communities, a comparative analysis of Sri Lankan law and international standards.
Thank you, sir. Good afternoon, Conference Chair and other distinguished guests. Our research was, Good afternoon, Conference Chair and other distinguished guests. Our research was based on the topic Development and Rights of Indigenous Communities, a comparative analysis of Sri Lankan law and international standard. The outline of our presentation will be introduction, research problem, objectives, methodology, impact of developmental activities on Badda community, international standards, domestic standards, conclusion, and recommendations. I would like to start our presentation with the quote by Justice Shirani Tilakawat in Vattigedara Vijayawada versus Conservation General of Forest and others. Humankind of one generation holds the guardianship and conservation of the natural resources in trust for future generations, a sacred duty to be carried out with the highest level of accountability. Environment plays a significant role for the survival of human beings. Both humans and the environment has an unbreakable balance which is essential for such survival. Development has become an inevitable aspect of life of the human beings. In the recent years, these developmental activities have affected the environment in a harmful manner. This has become a major problem throughout the world. When considering the Sri Lankan situation, it can be observed that due to the rapid development, the harm done to environment has been escalated. Several such examples are Umaoya Hydropower Project, Port City Project, and Central Expressway Project. Harms done to the environment affects directly to the human beings as they are dependent upon the nature. Every human being has rights which are inherent to them, but indigenous people have special rights which are related to the environment as they have a spiritual and cultural connection with the environment. Therefore, right to environment of the indigenous community plays a significant role in their culture. However, in Sri Lanka, it can be observed that this aspect has not given proper recognition when conducting developmental activities. The most recent example for the lack of recognition is Ramakanoya Pollabadda Land Acquisition Act. Therefore, our research problem is to assess whether the existing laws in Sri Lanka are adequate to protect the rights of the indigenous communities against adverse developmental activities when compared to the international standards. Moving forward to the objectives of this research, to define the indigenous community and their rights recognized in Sri Lanka, to identify how the rights of indigenous community are violated, to recognize the international standards which are applicable for the protection of the rights of the indigenous community, and finally, to assess how the international standards can be adopted in Sri Lankan legislation in order to strengthen the legal framework in protecting the rights of indigenous communities. Moving on to the methodology that we have used, this research was carried out as a library research, adopting the black letter approach by collecting data through primary and secondary resources. Black letter approach was adopted because the effective access to empirical data was challenging due to the prevailing pandemic situation in the country. Furthermore, it was carried out as a comparative analysis between Sri Lankan and international standards. International standards were selected due to its comprehensiveness and accuracy in addressing the issues of the indigenous community. The first part of our research focuses on the impact of developmental activities on Badda community. Who are indigenous people? Indigenous people are recognized as natives of a state who are culturally distinct. Indigenous community in Sri Lanka is known as Baddas. In past, Vedas have been scattered around the island, but now most of them have blended in with Sinhalese and Tamil communities. At present, majority of Vedas live in Eastern Province. Over the years, with the development, Vedas have gradually shifted from their original ways of living, such as hunting, and moved on to economic activities such as cultivation and trade. With this new background, Vedas at present are facing various difficulties in order to survive. Among these difficulties faced, impact of the developmental projects takes a prominent place. Some of the developmental projects which have affected immensely to the Vedda community are Mahavali Irrigation and Agricultural Extension Project, Post-Conflict Developmental Project, and the Ramakan Oil Irrigation Project. According to a research done in 2011 on Vedda community, it was reported that Mahavali Developmental Project resulted in fragmentation of Vedda's livelihood. The recent acquisition of land in Ramakan Forest Reserve for private investments has resurfaced these difficulties faced by Vedas as they are threatened again with losing their lands and livelihood due to the actions of the state. The Chief of Wanilatho and the Center for Environmental Justice filed a petition in the appeal court claiming that Mahavali Developmental Authority had begun a project on their land to cultivate maize without conducting an environmental impact assessment, thus resulting in the state violating the basic fundamental rights of the Vedda community of the Polle Vedda area.
When considering the protection given to the indigenous communities by international standards, Indigenous and Tribal Peoples Convention 1989 plays a major role. Article 7 of the Convention recognizes the importance of participation of indigenous people in national and regional development projects, which affects them directly. Article 14 requires the government to recognize the ownership and possession of the lands the indigenous people traditionally occupied. Also, in the emergence of necessity for relocation, indigenous people's free and informed consent is required by Article 16. Further, United Nations Declaration on Rights of Indigenous Peoples recognizes a diverse set of rights alongside the ILO Convention 169. In this regard, several international courts have also recognized that the rights of the indigenous community are not to be violated when carrying out a developmental activity. In Saramaka People vs. Suriname, the IACHR, after examining the rights of tribal people in international law, held that the members of the Saramaka people have a right to use and enjoy the natural resources that lie on and within their traditionally owned territory and that are necessary for their survival. In recent judgments given in Canadian and Guatemalan courts, it required that free, prior, and informed consent of the indigenous people must be obtained before their property can be taken or infringed upon. When considering about the Sri Lankan situation, it is evident that the indigenous people within Sri Lanka has the minimum rights and protection. Even though Sri Lanka has voted in favor of the United Nations Declaration on Rights of the Indigenous People, which was adopted in 2007. As Sri Lanka is not a dualist country, mere voting in favor of a convention does not make it a part of the common law of the country. The Constitution of Sri Lanka under Article 14H recognizes the freedom of movement and choosing one's residence in Sri Lanka. Under Directive Principles of State Policy, Article 2714 makes it a duty of the government to protect, preserve, and improve the environment. Article 28F states every person within Sri Lanka has a fundamental duty to protect nature and conserve its riches, and also 28E recognizes that every person should respect the rights and freedoms of others. But the protection provided for the indigenous community is limited by Article 29, as it provides that these provisions do not confer or impose legal rights or obligations, and any inconsistency with such provisions shall not be raised in any court or tribunal. State has not enacted a specific legislation or mechanism to protect the rights of the indigenous people. Legislation such as Fauna and Flora Protection Ordinance, Forest Ordinance, and National Heritage and Wilderness Areas Act have implemented various regulations which have deprived them of their hunting grounds and criminalized their livelihood. When considering the Polle Vedda situation, it is clear that the Vedda community has not been properly informed regarding the developmental projects, and their necessities and their rights have not been taken into consideration. There is no free, prior, and informed consent, as they were not participated in the decision-making process, while it was clearly visible that such development project would affect the Vedda community to a great extent. The importance of conducting an environmental impact assessment has been clearly stated in Bulankulam and others versus Secretary, Ministry of Industrial Development and others. Furthermore, in the case of Gunratna versus Homagam Pradesh Sabha, it emphasizes that public participation and right to information are two principles of EIA which should also be concerned. In conclusion, the indigenous people have adapted and coped with external and internal stresses which could easily result in vanishing them as a cultural group. One of the most prominent threats that can be recognized as exponential development and its effect upon their natural habitat. This can be clearly identified in recent land acquisition of Rambakanoe Forest Reserve and its repercussions on the Vedda community. Due to the lack of proper law enforcement, it has become challenging for the Vedda community to secure their rights. As discussed above, the international standards have comprehensively addressed protecting the rights of the indigenous people while conducting developmental activities. When comparing these international standards, it was evident that the Sri Lankan legal framework is inadequate to address the rights of the Vedda community. Therefore, this study, we recommend that legislature should recognize the indigenous community as a vulnerable group of people who need special protection. Right to a clean and healthy environment should be acknowledged. Environmental impact assessment should be mandated and a proper screening process should be implemented. Fauna and Flora Protection Ordinance, Forest Ordinance, and National Heritage and Wilderness Areas Act should be amended. ILO Convention 169 on Indigenous Peoples should be ratified and a time-bound plan of action should be implemented to ensure the adherence to the Convention and realization of rights of the Vedda community. Thank you.
Thank you very much, Nimtara and Meta, for a very comprehensive paper. Done a great deal of research and come to obvious conclusion that our laws are quite inadequate to address the issues, problems that face indigenous populations. In fact, I believe in Canada, the First Nations peoples, as they are called, I think they've used the right to life in the Canadian Constitution to enforce their rights, but we don't have even right to life recognized in our Constitution, quite apart from right to a clean and healthy environment or rights of indigenous peoples. So clearly, there is a need for a very comprehensive look at the rights not only of indigenous populations, but in so many other areas of, so many other groups of people. Shall we now move to the next paper, which is by Ms. Lalani Ashinta Rajapakse, an attorney at law and notary public and commissioner for oaths, who has more than 20 years experience in the legal field. She graduated with an LLB degree in 2005 from the Open University of Sri Lanka and obtained her master's degree in law in 2012 from the University of Colombo. She is now a senior assistant registrar responsible for legal and documentations at the Open University of Sri Lanka. I have great pleasure in inviting her to present her paper on personal data protection in the context of employment, a discussion of the law in Sri Lanka in the light of the general data protection regulations passed by the European Parliament. Ms. Rajapakse.
Thank you, sir. Good afternoon to all of you. I'm Lalani Rajapakse from the Open University of Sri Lanka. My research topic is personal data protection in the context of employment, a discussion of law in Sri Lanka in the light of the GDPR. This is the outline of my presentation today. Personal data can be interpreted as any information related to a natural person. The right of a person not to allow anyone to use his personal data without his permission is called data privacy or data protection. The term data privacy has been derived from the broader concept of right to privacy. With the rapid development of electronic records of information, the protection of data personal data has become a difficult task. This difficulty is more in the employment context.
Employees can be considered as one of the most vulnerable categories of persons whose personal data may easily be misused by the employer due to the unequal power between them. Therefore, there should be a mechanism to control collection and possession of personal data of employees. My research problem is, how does unequal bargaining power between the employer and employee affect the rights of personal data protection of the employee? What have legislation done to stimulate employee privacy and personal data protection by minimizing the gap of bargaining power? Will such legislation affect the interests of the employer? How to strike a balance between employees' rights to protect their personal data and the employer's interest of smooth running of the business? Research objectives are to identify the laws and regulatory provisions available in Sri Lanka on right to individual privacy and data protection, process of personal data of employees, to evaluate the provisions of the general data protection regulations of the European Union, and to critically analyze whether there is a gap between the GDPR provisions and the legislative provisions of Sri Lanka. Since this is a legal research, the most appropriate methodology is the qualitative methodology. So I used qualitative methodology. This is a doctrinal or reform-oriented research. My intention was to analyze the existing rules and regulations in this area and to make recommendations for the changes to be made. I gathered information through primary and secondary sources and analyzed them through the experience and logic. Moving to the results and discussion, when we consider the legal framework relating to the right to privacy in the international and domestic context, we can identify certain international conventions that have accepted right to privacy as a fundamental right. For example, they are UDHR, ICCPR, and ECHR. But in Sri Lanka, right to privacy, there's no legislative protection for the right to privacy. Even though there's a fundamental right chapter in the 1978 Constitution, right to privacy has not been accepted as a fundamental right. However, when we analyze the legislative provisions in Sri Lanka, we can identify indirect provisions regarding right to privacy. For example, Article 14(1)(e) of the Constitution, which has been introduced to the Constitution by the 19th Amendment, has indirectly accepted right to privacy. Computer Crime Act, Electronic Transactions Act, Right to Information Act, Banking Act, Telecommunications Act, and Intellectual Property Act also have indirect provisions on right to privacy. There are certain judgments that have accepted right to privacy in Sri Lanka, such as Nadaraja versus Obesekara, Hewamana versus Attorney General, and Ratnatunga versus the state. When we see the difference between the right to privacy and the data protection, the right to privacy has been interpreted as preventing others from interfering with one's private and family life. On the other hand, the data protection has been interpreted as the right to keep control over one's information. Within this interpretation, even indirect legislative provisions are not available in Sri Lanka regarding data protection. There's a draft bill on personal data protection, but still the parliament has not passed it. When we consider about the employment context, there are many instances where the employers are collecting information about the employees. For example, at the recruitment level, many documents are collected by the employers, such as birth certificates, identity card, passport, etc. The work and performance of the employees are monitored by obtaining their signatures or fingerprints, and sometimes CCTV cameras are fixed to monitor their movements. Employers are empowered to collect those information and process them by most of the labor legislations. In the state sector, the empowering law is the Establishment Code. Therefore, there should be a legislative protection for the processing of personal data of employees. However, in the general data protection regulations of the European Union and also in the draft data protection bill in Sri Lanka, there are no special provisions on employment context. Article 88 of the GDPR requires member countries to make specific rules on employment context. In our data protection bill, there is no reference for the employment context at all. However, when we analyze the definition given for the term data processor in the GDPR and also in the draft bill in Sri Lanka, we can argue that the employer can be considered as the processor and therefore the employee as the data subject. Therefore, all the regulations regarding data processing in the GDPR and the draft bill in Sri Lanka will be applicable for the employment context. When we see the main features of the GDPR and the draft bill in Sri Lanka, the provisions of these two instruments are more or less similar. There are 6 principles on data processing. That means anyone who collects and processes personal data of individuals shall adhere to these 6 principles. There are 6 lawful bases and also there are 6 rights of the data subjects. When we compare those requirements in the GDPR and the draft bill in Sri Lanka with the existing law in the employment context in Sri Lanka, there are certain problems in the existing law in Sri Lanka. For example, under the principle of storage limitation, personal data shall not be kept for a longer period than necessary for the purpose of processing such data. However, in the public sector employment, including the public corporations, the personal file of a retired employee shall be kept for further 10 years. If the employee has been dismissed or resigned or sent on compulsory retirement, then the personal file shall be kept for further 25 years. Almost all the information of the employees are maintained in their personal file. Therefore, this requirement in the public sector is inconsistent with the principle of storage limitation. There are certain rights given to the data subjects, such as right to access, right to rectification or completion, and right to the erase of personal data. However, in the employment context, there are so many restrictions to access to the information maintained by the employer. In the state sector, these restrictions are there in the Establishments Code. However, certain restrictions have been removed in the state sector after enacting the Right to Information Act in 2016, but those restrictions are still there in the state university sector. Under the Declaration of Assets and Liabilities Law of Sri Lanka, very sensitive financial data of public sector employees are collected annually. The intention of this law may be to prevent public employees from misusing public funds, but this seems too much of intrusion to their privacy. So therefore, my conclusion and recommendations are prevailing regulatory provisions in Sri Lanka have more concern on employer privacy rather than the employee privacy. Even the GDPR and the draft bill in Sri Lanka has paid less attention on employment context. Within the interpretations given for the terms data controller or processing the GDPR and the bill in Sri Lanka, it is concluded that all the provisions in those instruments are applicable for the employment context without distinction. Having legislative control over employee surveillance and processing of personal data by the employer will enhance the trust between the parties, and thereby the employer will get ultimate benefit through the increased productivity of the employees. Since the public sector employment in Sri Lanka, including the state university sector, is governed by the establishments codes applicable to them, certain provisions of those codes will have to be amended once the Personal Data Protection Act is enacted. These are my references. Thank you very much.
Sorry, my mistake. Thank you for very incisive analysis of the existing law and what we do not have. And basically, I think the lack of a recognition of the right to privacy, as you pointed out, is something that ought to be remedied, because one cannot go looking for it among other rights. The right to privacy is fundamental, and any regulations or laws that are made thereafter will have to conform to the principles embodied in that right. I think this is a very useful paper, and I hope it will be found, be published, and will be of use to our legislators and people who are formulating laws on this subject. Thank you very much. The next paper is being presented by Avani Samarakoon, law graduate of the Kothallawala Defence University, who is currently a final year student at the Sri Lanka Law College, and also reading for a Master of Laws in International Business Law at the Cardiff Metropolitan University. Her research interests are commercial law, criminal law, and labor law. Then there's Vishna Liyanage, law graduate of the Kothallawala Defence Academy, also a final year student at the Sri Lanka Law College, and her interests include environmental law, criminal law, and constitutional law. And finally, there's Mr. Viduravi Purasandu Liyanage, a preliminary year student at the Sri Lanka Law College, whose research interests include environmental law, criminal law, and intellectual property law. Now, the paper which they intend to present is on the right to internet access for the development of online education in Sri Lanka during COVID-19, a comparative analysis of Finland, France, and India, a very timely, relevant subject. Thank you. Avani, are you presenting it? Yes, yes.
Thank you, sir. Honorable Chair, ladies and gentlemen, our research topic is right to internet access for development of online education in Sri Lanka during COVID-19, a comparative analysis with Finland, France, and India. Impact of COVID-19 on labor rights and national economy has become a prominent issue at present. As a result of COVID-19, national economy of Sri Lanka was highly affected. This decreased the national growth. For example, the Colombo stock market was highly affected by this unenforceable pandemic, which reduced the national growth of country. Due to this, the profit of companies were drastically reduced, and many issues relating to labor rights have occurred. The aim of this research is finding out whether there are sufficient laws to protect right to online education of children in Sri Lanka during COVID-19 pandemic. The research problem is whether the prevailing laws in Sri Lanka are sufficient to safeguard the right to online education of children during COVID-19 by ensuring the right to internet access. And the objective of this research includes identifying the impact of COVID-19 to education of children, identifying whether the Sri Lankan legal framework is sufficient to address such issues, and to propose necessary amendments to the existing legal regime to fill the gaps. Here, the research methodology would be a combination of black letter and comparative research methodology with Finland, France, and India. This employs a qualitative analysis of primary data and secondary data. The information was gathered using a questionnaire to identify how the pandemic has affected the online education of students. Accordingly, most of the respondents are from rural areas and are using Zoom and LMS for education purposes. Since most of the respondents are from rural districts, they are facing internet difficulties due to lack of signal, and 50% of the respondents mentioned that online education was affected by the less speed of the internet. And 65% of the respondents stated that online education was affected by signal issues, audio issues, and reconnection issues. 64.4% mentioned that they have faced financial difficulties when attending lectures through online platforms which have restricted their right to online education. Additionally, 58% stated that the government intervention is inadequate in this regard, and 60.4% respondents were of the view that the government intervention is inadequate in this regard, and 60.4 respondents were of the view that the government should recognize right to online education as a fundamental right. Next, I'm going to discuss the Finland legal regime on right to internet access on education in Finland during COVID-19. Finland has become the very first country in the world to make the internet a legal right for every resident. Finland is one of the countries in the world where around 95% of the population has a type of internet access, and the law has intended to carry the internet to rural areas. Because of the school closures due to COVID-19, alternative strategies such as digital learning environment, distance learning, necessary arrangements, and independent learning have been introduced in Finland to secure right to online education of children. For example, Helmi, Wilma, Student Plus are the basic platforms which have been utilized for both primary and secondary education in Finland during COVID-19. But the admittance to vital computerized gadget is not similarly conveyed over the populations, and therefore the students from socio-economically disadvantaged background who do not have the way to admittance to these electronic devices might be seriously affected by the COVID-19 pandemic, which will lead to expand the learning imbalances. However, Finland has taken considerable initiatives to protect right to education of children during COVID-19 by ensuring the right to internet access to everyone. In June 2009, the Constitutional Council, France's highest court, announced access to the internet to be an essential basic liberty and declared internet access as a fundamental human right. Rather, an online portal known as My Class at Home gives admittance to educational and learning opportunities, upholding the judgment of the French court to protect the right to education of children to a considerable extent during COVID-19 by ensuring the right to internet access of everyone. When discussing the Indian legal framework, access to internet had been declared as a fundamental right by the Indian Constitution. In Fahima Shireen versus State of Kerala, the right to internet access was recognized as a fundamental right which forms part of both right to education under Article 21A of the Constitution and right to privacy. Article 21A of the Constitution provides for free and compulsory education for all children between 6 to 14 years as a fundamental right. The right of children to free and compulsory education Act 2009 describes the importance of free and compulsory education for children between 6 to 14 years in India under Article 21A of the Indian Constitution. Furthermore, many free digital e-learning platforms which assist students in continuing their learning during COVID-19 due to school closures were introduced. The Diksha portal, e-Pathashala, the National Repository of Open Educational Resources, SWAYAM and SWAYAM Prabha would be illustrative of these free digital e-learning platforms. Therefore, it is evident that Indian jurisdiction has sufficiently addressed right to internet access on education in India during COVID-19 through its legal framework and by taking many other initiatives to protect right to education of children during COVID-19 by ensuring the right to internet access. The system of free public education was introduced to Sri Lanka by Dr. C.W.W. Kananga, the father of free education, by making education free for all students for their own benefits, including underprivileged students in rural areas of the country. Therefore, the students from economically marginalized families will be ensured the access to education. This is further guaranteed by Article 12(1) of the Constitution, which stated all persons are equal before law and are entitled to equal protection of law. Moreover, according to the directive principles of state policy and fundamental duties under Article 27(5) of the Constitution, state shall take effective steps in the field of teaching, education, and information to eliminate discrimination. The outbreak of COVID-19 has led to create adverse impact on education of children in Sri Lanka. This resulted in halting academic activities in schools, universities, and higher educational institutions for some time. The Sri Lankan government has proposed online education as a solution to address this issue. However, it could be argued that there are many issues arising out of online teaching through various online apps. Technical issues would be illustrative of this. The main disadvantage in online teaching is that it excludes students who lack economic strength to buy equipments which are essential to connect with online lectures. Moreover, some students are marginalized for being unable to bear the cost for data or Wi-Fi. They are further disadvantaged due to the decreasing economic capacity. Due to the COVID-19, which directly resulted in affecting the livelihood of their parents as well as them adversely. On this basis, it is necessary to introduce new laws to the current domestic legal framework with the view of protecting online educational rights of students in unforeseeable situations such as COVID-19, and it should be recognized as a legal lacuna that should be filled promptly. So, I would suggest the following recommendation to address the state issues. Right to online education should also be incorporated as an express right to be included in the 1978 Constitution under the Fundamental Rights chapter. Online teaching should be implemented with wider consultation to be made available to all students without discrimination on any ground such as poverty. Enact legislation to ensure the safe use of internet by children for online education. The study reveals that the existing laws are not sufficient to address the issues relating to right to internet access to online education in Sri Lanka during COVID-19. Hence, it would be effective to introduce new laws to effectively address this issue. Thank you, sir.
Thank you, Avani. I think this is a paper that should be made available to the Ministry of Education. You referred to the right to equality together with the directive principles of state policy. The problem is that our lawyers have always relied on the right to equality, whatever the situation, without looking at the other rights that are guaranteed by the Constitution. And secondly, the directive principles are not enforceable. What we need is a recognition in the Constitution, as you mentioned, of the right to education. It's there in the International Covenant on Economic, Social, and Cultural Rights. We have signed it, we have ratified it, but we have not incorporated that in our law. And I think it's a long, long time since it's long overdue. I don't know whether the people who are drafting the new constitution are going to take account of that, but that is what we require. The right to education it's globally recognized, but we do not do it legally. So that's fundamental. Thank you very much. That's a very useful paper, very clear analysis of the problem that exists and a current problem, a very topical problem that has led to strikes and so on, replacements of ministers and various things. Anyway, now we'll get on to the next subject, which is, I suppose, of interest to everybody. The authors are Ms. Jeewanthi, who obtained her bachelor's degree in law and the master's degree in law from the Faculty of Law of the University of Colombo, and is now a senior lecturer in the Department of Legal Studies at the Open University of Sri Lanka. She has also completed the postgraduate diploma in criminology and criminal justice offered by the University of Sri Jayawickrama, and is currently reading for MPhil and PhD at the Faculty of Graduate Studies, University of Colombo. Associated with her or together with her is MKG Kaneshika, who obtained her BSc in physiotherapy from the Faculty of Allied Health Sciences Unit, Colombo University, and is serving as a senior physiotherapist at the MJF Charitable Foundation in Moratuwa. She has completed the postgraduate diploma in health development and certificate course in postgraduate research offered by the Faculty of Medicine, University of Colombo. Their paper is something unique. It's, not many people would have done research on the subject of obesity, but it is relevant. And I think the longer that our lockdowns continue, it's going to be a problem that's going to affect all of us. So let's hear the subject, Geethani.
Yeah, Honorable Chair, thank you very much for the kind introduction, and the other paper presenters. For all of you, I will wish all good afternoon to everybody. And let me share my presentation. Yeah. Hope you can see my presentation.
Yes. Yes.
Yeah. Okay.
Yeah.
Sorry. Yeah, I think you all can see the topic of my presentation. That's something about obesity. And also by looking at this picture, also I think you can get an idea about where we are heading right now. This is an evolution of the people and we are currently heading to somewhere. So that is the major topic that I'm going to discuss in this topic. So this is the basic outline of my presentation. And when it comes to the introduction, I will give a brief introduction about regarding main 4 points. So the very first point is to make you aware that obesity and overweight is also a one form of malnutrition. But when we heard about the malnutrition, normally we imagine person who is thin, who is lack of food. But according to the definitions of the WHO, abnormal or excessive fat accumulation due to the unhealthy food also, that is also considered as a one form of malnutrition. And this form of malnutrition or the obesity can lead to different ill health conditions. And this severity or the gravity can be easily seen with some of the research done during this pandemic period. Recent studies actually emerged from multiple countries and multiple studies has proved that there is a link between the death rate and the obesity. And I have pointed out some of the researchers in this slide. And BMI is identified as a powerful indicator of the illness severity of the people. So you can see even if I read some of the report, even in the Sri Lankan context, it is a common case. People who is obese and people, because of the obesity, you tend to have so many other diseases. Because of these diseases, you tend to be more vulnerable if you are contaminated with the coronavirus. So that is the 2 points of my introduction. The other 2 points is obesity can be occurred due to many reasons. Maybe your medical conditions and the genetical factor also lead into that cause. But WHO and also some of the other researchers, as I have mentioned here, have clearly proved that there is a link between the obesity and the consumption of unhealthy food. So then what does it mean by the unhealthy food? Unhealthy food is, there are so many other things, but I have categorized, and even the researchers and reports have pointed out according to these levels that food with high sugar, food with high salt, and food with trans fat, these are identified as the major unhealthy food which lead to obesity. And I have here pointed out, even in my research paper, I have pointed out how this scientifically this happen, why you're taking sugar and how it affect to weight gain and those kind of things. But these things actually I'm not going to discuss in this limited time period. So with this introduction, I'm going to achieve 3 main objectives. The very first objective is to see whether there is other kind of human right violation happening because of this obesity. The other objective is just to see, is there any kind of a state party obligation to address this issue? Because what you are going to eat for your dinner may be your choice. But is there anything to do from the state party? That is the question. Because if the food that you are taking, that may be your choice. But if the food that is you are going to choose for your dinner is leading to the obesity and leading to a different health consequences, that is a problem. So in that case, actually, state has a responsibility. I will discuss this within the detail. And the third objective is to see the possible remedies for this. This is a legal research, and this is not kind of the policy reform level or kind of a recommendation, this thing, but I'm just looking at this as a theoretical angle just to see how we can address this issue under the human right based approach. And the base theory of my research is a human right based approach. So then when it comes to achieving discussing the very first objective, it's clear, I pointed out earlier also, obesity can lead to different ill health conditions. So definitely your right to health has been violated, and the right to health is a fundamental human right that underpins all human rights. We are all under lockdown because of this health issue. We know how this is affected, and this right to health is that kind of a right which is recognized under the UDHR Article 25 or ICSCR, and also the general comments giving under the for the general comment 14 given for the right to health also determine right to health is an inclusive right which even include the safe food and the nutrition. So by being obese, your right to being health is violated. Then the other right is the right to food. So is it right to food? Some might think like that, because right to food, traditional mode, right to food was like just to think whether if you have enough food, okay, your right food is fulfilled. If you don't have the enough food, then it is valid. But currently it is not the case. By the passage of time, the definitions has been changed, and it's like right to food is not just feeding. It's like the food that you are taking should lead to a healthy and active life. If it is not the case, actually the right to food is not, you're not enjoying your right to life. And the definition given to the food security in 1996, the food security definition, it includes food security means when all people all times have physical and economic access to sufficient and safe and nutritious food. So if the foods are not safe enough, so it's not, your right to food is not fulfilled. That is the definition given even under the general comment number 12 given for the article 11 of the ICSCR. And also the right to life. Now, right to life is life, we know the definition, like it should be the natural death. But the obesity may cause unnatural death or a premature death. Right? So then, by allowing people to consume as much as they like, and allowing them to have the unnatural death or a premature death. And I proved earlier that with the coronavirus pandemic statistic, there's a huge link and people are getting died because obese people are more tend to get died. So then there is a threat to the life. Not only these three main rights, but also the other rights like non-discrimination. Obese people are sometimes tend to be discriminated, especially in school level. Kids are, bullied by the other kids, and right to education, right to privacy, freedom of association, those kind of rights can be violated. So it's the first objective I'm achieving, that I have proved that there is a other right violation because of the obesity. The second objective is to discuss the state party obligation. Under the state party obligation, general obligation and specific obligations are there are two natures. General obligations are mentioning in the Article 2 of the ICCPR and all the and the ICCPR and the ICESCR. Here I have mentioned about the ICESCR because I'm mostly focused on the right to health and the right to food, which considered as ESC rights. They are actually there. The problem with the definition of the Article 2 is, state are not immediately bound to provide immediate effect to the rights which are mentioning in the ESC. So then it's kind of progressive to full realization. But the matter is, we started somewhere in the ESCR somewhere in the 1966. Are we still progressive to full realization? So do we have plans to achieve this? So that's a matter. But and again, states are required to take actions. And ICCPR, if we take the right to life, something actually state has an immediate effect, should fulfill those rights for their individuals. And when it comes to the specific rights such as right to obligation to respect, protect, fulfill, and promote, and those kind of things, although state has a responsibility. And the definition of state responsibility go beyond. It is not like, a state may not directly violate your right, but that violation can be taken place from a third party, maybe a factory, maybe a company, maybe a food selling outlet or whoever. But if that third party's action is amount to violation of that particular individual, state has a responsibility to address that issue, because that level that state responsibility has recognized. So state, it's kind of like if the state is not taking action, it's kind of an omission. Even the omission of state parties can be addressed under the human rights regime. So then I have achieved my second objective. The third objective, actually, I'm discussing this in the main two angles. The very firstly, under the human rights perspective in the other slide. The other steps that can be taken, that will be the end of my presentation. When I come to the human rights perspective, how we can address that is the theoretical thing that I'm adding to the literature, that or the major finding, that is under the justiciability, whether we can make a standalone case based on right to health or food. For that, actually, we need to have a recognition for the right to health or right to food under the constitution. Countries like South Africa, Brazil, Mexico, they have. And also we can, as earlier mentioned by the Honorable Chair, directive principles are not justiciable, but what we can do is cases like Olga Telly's cases in India, we can get the support, and we can, when it comes to the interpretation, we can get the support of the directive principles. So then that is one option. If that option is yet failed, I think that's the major point, that we can base a case on the right to life. There are some cases, very first case here mentioning from the Indian case, the second one is a Bangladesh case, and the third one is the Irish case. So all these cases have identified and broadened the definition of right to life to include, if the actions or the other things is lead into unnatural death or some kind of thing, it's kind of a right to violation. And the right to life violation. Right to life include the safe food and nutrition. So then we can have a case based on that. And this slide, actually, I'm not going to discuss. You can see the other actions that can be taken by the state or the other sectors to address this issue. For example, industrial reformulation, it can be a voluntary or a mandatory basis like UK, Argentina, and we can have fiscal policies raise the prices of unhealthy food, so that can lead to the reduction of sales of those kind of food. And also, labeling regulation, advertising, regulating advertising, marketing, those kind of actions that can be taken. And finally, it's a responsibility lies with all of us, not only the state. The state should regularize the legal framework and everything, but it's all our responsibility. We should, even in our home cooking and everything, we should consider that and address this issue. Otherwise, we will end up with a very devastating situation. Thank you very much.
Thank you, Geethani. That's a very, very comprehensive examination that has been made. Quite honestly, I haven't come across such a comprehensive examination of this subject before. I wish it's available to the decision makers in government, the people who formulate policies, laws, because it's excellent. It's excellent analysis, and I'm so happy to be have been able to listen to it today. The next paper, which I think is the last one, is by Miss IK Munasinghe, which is on the subject. She is a senior lecturer of the Faculty of Law of the General Sir John Kodalawala Defence University, and she has a law degree from Colombo University and a master's degree in law from Wales, and MHR Colombo, and postgraduate diploma in what's HR? Is it human rights or human resources? I'm not sure. From the University of Colombo. The subject of the paper is legislating the principle of best interest of the child, the Sri Lankan standpoint. Is Miss Munasinghe here? Ishara Munasinghe, yes.
Good afternoon, Honorable
Yes,
Chair. Good afternoon, Honorable Chair and the colleagues. Today I'm going to talk about the legislating the principles of the best interest of child, the Sri Lankan standpoint.
I'm sorry to interrupt, but did I introduce you or was it muted?
No, sir, I can hear you, sir.
All right.
Yeah.
I found that
Am I audible, sir?
You're audible, but I was wondering when I was introducing you whether I had muted.
Yeah. No, it's all right.
It's okay, Sarah. Thank you.
Right. Now, introduction of the study. The principle of best interest child has been more of a tool developed by the judicial activism in par with the international and regional and domestic legal social norms of a particular state in order to secure the rights of the children. On the other hand, it lays the foundation to secure the minimum level of protection that required to be offered for the children in its crisis of their rights. There has been much steps taken by the judiciary and other administrative means to uphold the same in the most of jurisdictions. The more state driving this set approaching that is the best interest of principle into proper legislative enactment as appropriate. This Sri Lanka has more of towards incorporating the principle into the different legislation in order to secure the justiciability of the rights of the children. The study intends to incorporate legislating the principles of best interest child in the selected Sri Lankan statute enacted between 2000 and 2009 in terms of safeguarding, upholding the rights of the children. The study employs the doctrinal research methodology to elaborate the context where the qualitative research method is used to gather the evaluate the gathered data. The domestic legislations, including the Constitution, along with the few selected statutes, international instruments, state party reports submitted to the relevant treaty bodies, concluding observations, were used as a primary source of this study, whereas books, journal articles, and the reports by the government expert, etc., were analyzed as a secondary data in order to unpack the research question. The principles of best interest of the child in terms of the United Nations Convention of the Rights of the Child. This Article 3 of the same, it describes the best interest principle along with every legislative, administrative, and judicial body or institutions to apply the test of principles by the systematically considering how children's rights and interests will be affected by their decisions or actions which uphold the paramount consideration of the best interest of the children in every concern. The same had been explained by the General Comment 14 as the best interest principle operates as both of the substantive right and the interpretative device, while emphasizing added on the level of obligation incorporated Article 3.1. According to the committee, the Article 3.1 creates an obligation for the state is directly applicable and can be invoked before a court. The committee also acknowledged the role of Article 3 as interpretative legal principles, observed that if a legal provision is open to more than one interpretation, the interpretation which most effectively serves the child's best interest should be chosen. Therefore, the scholarly argument has been developed that the level of establishing the principles of the best interest child created two different dimensions with the interpretations of Article 3 and Article 21 of the CRC. On the other hand, the perspective of best interest as a primary standard of concern may encourage the exercise of discretion with awareness of the dynamics of the child's own environment. Making children interests primary concerns will thus be useful in creating sensitivity to the need for the holistic perspectives of the rights of the child. Upholding the best interest in the child, the Sri Lankan perspective, I would describe this in three separate topics. The first one would be the level of understanding UNCRC obligation towards establishing the protection of the rights of the best interest of children. The Sri Lanka ratified the UNCRC on July 12, 1991 by introducing Children's Charter is a guideline on rights of child protection inside the state. Moreover, the responsibility of the state to take all appropriate legislative, administrative, social, educational methods to protect the child from all form of physical, mental violence. or abuse, neglected treatment has been indicated in par with Article 20 of this Children's Charter, in line with the Article 19 of the CRC. Again, the level of undertaking the protection of the rights under supreme law, Constitution, it says Article 12(4) and Article 27, paragraph 12 and 13, and then it could be interpreted as a state directorative policy as fundamental duties. Then the justiciability of the best interest child under the statutory means. The UNCRC committee recommended that in 1995, the Sri Lanka shall harmonize its national legislations with the provisions and the principles of the convention at the stage of submission of the initial state party report submitted to the treaty body. Further, it was emphasized the necessity of the reflective principles relating to the best interest of the child and the prohibition of the discrimination in relation to the children in domestic law, and ensuring the validity, justiciability of the standard. There has been even recommended by the UNCRC committee, the state party to ensure the domestication of the convention rights of the child in the national legislation, so that all the principles and the provisions convention could be applicable in courts. Therefore, a requirement of legislating the principles of the best interests of the child had been emerged, and the domestic legislations have actively contributed to fulfilling the same objective with introducing many statutory mechanisms other than the traditional aspects of custody, adoption, guardianship matters of the children, divorce of parent coupled with maintenance. An assessment of Sri Lankan statutory directions. The paper described the assessment via selected statutes. As per the terms of Article 3 UNCRC, as previously mentioned, the application of the principles of the best interest child shall be incorporated to an enactment after concerning how children's rights and interests are or will be affected by the introducing said legislations. Therefore, it is worthy to scrutinize the justiciability of the principles of best interest over the words of the few legislation attempts taken by Sri Lankan Parliament between 2000 and 2009 beyond the traditional discussions of best interests of Sri Lanka. The Employment of Women and Young Persons Children Amendment Act in 2003 was an amendment to the Employment of Women, Young Persons and Sri Lanka Act of 2003, which strengthened the children labour law by increasing the minimum age of 12 to 14 years while establishing the prohibition of the employment children under the age of 40. This law guaranteed the best interests of children in terms of Article 3 of the UNCRC while enhancing the sentence for violation of the provision by the people of the state. Citizenship Amendment Act number 16 of 2003, enacting this law relating to the citizenship makes a revolutionist approach towards the rights acquiring citizenship nationality of the children, which amended the previous law as enabling the children to acquire the nationality from both parents. Under the previous laws, it only be the fathers who was able to pass the Sri Lankan nationality to Sri Lankan, which led the discriminated children as per the terms of the best principle of the child. Then it marks a tremendous landmark in the Sri Lankan history by introducing the Tsunami Special Provisions Act, which had been resulted to a major natural disaster occurred in Sri Lanka and massive personal property crisis among the people lived in the coastal area, the coast. Lots of children were experiencing very vulnerable due to the loss of parents, companionship, security, custody, along with the maintenance and non-realization of the other social, cultural, religious rights which they were used to enjoy. However, the statute laid the legal foundation for the children who were vulnerable to secure their best interest of custody, foster care, adoption matters with the active participation of the responsible of state authorities. Further, the law guaranteed the monitoring sanction process of realizing the realizing the rights of the tsunami-affected children to secure their personal interest. Then the Prevention of Domestic Violence Act laid the foundation to secure the best interest of the children from the physical, psychological violences occur due to the actions or the omissions of the family members inside or outside of the residence. The state statute provided the space to children to raise their voices against domestic violence or the imminent violence, which shall be affected to their social, cultural, religious rights. The law enabling the protection orders urgently obtained by the safeguarding the suffering and risk of the domestic violence, including in the uncleared extended families through the judicial mechanism. Then the Penal Code Amendment 2006, it was derived through strengthening the law against child trafficking, including that of by the electronic media. Then finally, the International Covenant of Civil and Political Rights, which guarantee the best interest of the child, shall be paramount importance as all matters concerning the children by the courts, administrative authorities, legislative bodies, and the public and the private social welfare institutions. Protection of the children, respect of their birth registration, name, nationality, and legal assistance. This enactment remarks the outstanding principles of recognition of the best interest of child. Concluding my study, understanding and interpreting best principal interest of the child in the context the children arises nature of the sui generis. However, the dispute of the children shall be obviously taken up the courthouses as use of the best interest as a tool to resolve the matter in order to guarantee the paramount consideration. Further, it is more precise to observe the utility definition for the child in all above-mentioned statutory instruments, which make judiciary more comfortable in applying the law into the issues referred to the courthouses, while promoting and ensuring the uniform application of the best interest. And again, finally, I would recommend some of the social and legal things that we could implement in order to ensure the subsequent equality of applying the principles of best interest through the legislative instruments. Number one, it is vital to promote the education on the rights of the school children while enhancing the parenting education to parents and teachers. Number two, educating members of the legislature, members of the Department of Police, judicial officials, probation officers, and all the involved in the juvenile justice on the way to handle the issues related to the children will be enhanced. Number three, the child care authority shall encourage to actively involve in resolving the matter in part of establishing substantial and procedural equality. Number four, introducing immediate amendment rectification to the existing laws, which shall not have the reflecting of the paramount consideration of the best interest of child. Necessity of enhancing compulsory transparent monitoring process and or any other measures which could be guaranteed to the victimized children in order to secure the best interest. Finally, the state party to ratify the CRC and option to recall the CRC in the form of enabling statute as recommended by the treaty body of UNCRC. Thank you. Thank you very much.
Thank you very much, Ishara. Thank you. I'm advised that we have very little time left, and perhaps for one or two questions. Are there any questions to the presenters?
Good afternoon, Dr. Jayawickrama. I am Dr. Rodrigo.
Yes.
I am Dr. Rodrigo, former principal of Sri Lanka Law College. I have a problem with the title of the third paper. So I would like to ask Ms. Avanti Samarakoon, because in her recommendations at the conclusion of her paper, she suggested that there be an express constitutional guarantee for internet access for the development of online education. But what I believe is that there is only a detail or an aspect of the general right of education, which although there is no express provision guaranteeing the right to education in our constitution, in Vishal Bakshi versus the Commissioner of Examination, the Supreme Court of Sri Lanka has recognized that our constitution impliedly recognizes the right to education. So now the present epidemic COVID-19 situation is an unforeseen, unprecedented situation. So therefore, I think that right is wide enough to deal with this aspect as well, because the Supreme Court has already recognized that there is an implied right to education. So the Supreme Court has written into Article 12.1, under Article 12.1, the right to education. So there is a comment that I would like to make rather than a question.
But not a question. Okay, thank you. The problem with implied recognition is that when it comes to, I don't know to what extent, what degree of protection is offered by these implied protections, because we have in many areas, we are depending on that. Any other question? One more question? Anyone would like to ask? No? Okay, then perhaps it's time to conclude it. I would like to say that I find that this has been a very useful exercise, because the topics on very topical topical issues, and in my view, the papers were of very high quality. I don't know whom I should congratulate, whether it's individual researchers or the Faculty of Law of the Kothalavala Defence Academy, perhaps both, because they're all alumni. Most are alumni of the Faculty of Law. I found the papers to be subjects were very comprehensively examined, and as I said, they were very impressive. And I wish that these reach the decision makers of in our country, because they don't seem to have access to papers of this nature produced in such depth. What they have in this session, what the papers have demonstrated is that, as Dr. Rajago said, we depend on implied provisions and guarantees, but we have not recognized in our constitution the right to life. We have not recognized the right to privacy. We have not recognized the right to education. We have not recognized the rights of the child, although there are references in the ICCPR Act. We do not recognize expressly, in a very comprehensive way, the rights of indigenous communities, and perhaps they can find recourse to the right to life, but right to life is not recognized. So there are so many areas in which we, for years, ever since 1972, when constitution drafting was undertaken in this country, we have omitted references to what are today basic fundamental rights recognized in constitutions throughout the world among civilized communities. So I hope that your research papers will be published, they become known and accessible by the drafters of the constitution, by the lawmakers in this country, and that they will contribute towards help perhaps to reach certain goals which we ought to reach very soon. Thank you everybody for participating in this session. I must congratulate the Faculty of Law of the General Sir John Kothalavala Defence University, and of course all the presenters for papers of an extremely high standard. And believe me, I'm not flattering you, that this is honestly what I feel. They were of a very high standard, original work, and very impressive. Thank you very much.
Thank you very much, sir. It has indeed been a thought-provoking, enriching session. I would like to thank the Honorable Chairperson and all the paper presenters for their esteemed presence here at this session. Ladies and gentlemen, with that, we conclude Technical Session 3. The Technical Session 4 of the day will be commencing at 2:30 p.m. Kindly use the same link to join the session.